Liberty Nation with Tim Donner.
And now it is time, he would say beyond time, to welcome back our regular contributor, constitutional lawyer, LibertyNation.com legal affairs editor, and he likes when I call him this, our guardian of individual liberty, Scott Cosenza. Hello, Scott.
No, Tim, I love it when you call me that. Hello.
Yes, you do. Guns at the Supreme Court.
Oh, yeah.
That's a joining of two of your most passionate issues, guns and the Supreme Court. What do you have to report?
Tim, this week the Supreme Court heard a case out of New York City where the Rifle and Pistol Association sued to challenge a law that prevented, and you're going to say, really? Yes, really, Tim. It prevented gun owners in New York from removing the firearm that they were legally able to own from their home to another place where they were legally able to keep a gun. They could only take it to one of 7 approved ranges in the city. So what this means, Tim, if, for instance, you owned a place in New York City and had a gun there, and then you had a place upstate where you spent summers or weekends or whatever, you weren't legally allowed, even if it was disassembled and locked in the trunk of your car, to travel from one place to another with it. So the New York State Rifle and Pistol Association sued the city to challenge that law on the grounds that it was violative of the Second Amendment rights of the people. But there's another sort of second component to this case, Tim, which is the issue of mootness. And so what happened was, because the law itself was so likely to be struck down as unconstitutional, and those the anti-gun people were scared that when it was stricken down, or when it would have been stricken down, that it would have been an opinion that granted sort of a bright line, wide rule bolstering the Second Amendment rights of Americans, that they ran and changed the law so that they could go back to the Supreme Court and say, oh no, please don't accept this challenge because the law has changed. There's no more case or controversy here for you to rule on. So the justices will rule, Tim, on one or maybe 2 issues. The first issue they'll tackle is that mootness question. Is this a live case or controversy for us to rule on? If they say yes, as a majority, then they will rule on the gun control issue itself.
Let's move to something that will take a little bit of explanation, because when you hear the word sanctuary, you immediately, in the political context, think of sanctuary cities that house any illegal that wants to come, such as San Francisco and many other cities and counties across the country. But here in Virginia, our home state, there's a sanctuary county movement that has nothing to do with the illegals, but a lot to do with firearms.
Tim, ever since the November election, when Democrats won a majority in the Virginia legislature, they have telegraphed their intention to deluge the Commonwealth with new and onerous gun controls. The Commonwealth of Virginia is a place that is a liberal state when it comes to gun rights, and these laws, if passed, would make us, if not the most restrictive, one of the most restrictive. So gun rights and activists and just people who wish to maintain their gun rights have petitioned their county and state governments to sort of rebuke and be a buffer to this state encroachment. They call it Second Amendment sanctuary, and basically what it is they're asking them to pass resolutions that say they will not cooperate with any attempt to remove firearms from the law-abiding.
Now, the big question to follow up on this is what kind of force of law would be behind an individual county declaring itself a sanctuary county for firearms? Is it a greater degree of certainty that they could do it than, say, a city or municipality or county declaring itself a sanctuary county or city for illegals?
Well, Tim, for instance, if you take a look at the office of sheriff, the sheriff is an elected position that has a sworn duty to uphold the Constitution of the United States. So if the sheriff believes that it's unconstitutional, any of these measures that may pass, they're an independent actor, and they're duty-bound to do so. So I think that it varies depending on the office involved and depending on their charter of governance.
All right. We never thought this name was going to come up again. But here we are again. He's back. Trayvon Martin. Not him, of course, but him as a story because he's being sued by a man famously described by a new demographic which was invented by the
Right.
left-wing
Forgot about it.
media, white Hispanic George Zimmerman, because God forbid, Scott, anybody could think that a Hispanic of some color could possibly have done what George Zimmerman did to Trayvon Martin, but he is now suing Trayvon Martin's family. Why?
We were debating the genesis of that line earlier today. It was
Yes.
CNN, Tim, I believe, that invented the white Hispanic.
I'm still going with the New York Times,
All right,
but
well.
I'm going to do deeper research
Okay.
on this.
Tim, this suit comes from a filmmaker called Joel Gilbert, who published a film called The Trayvon Hoax, Unmasking the Witness Fraud That Divided America. And what he has discovered, Tim, is that, if true, the Martin family and prosecutors conspired to keep the real person who was on the phone with Trayvon Martin. You may remember that was one of the key sort of parts of
Yes.
that story. And there was this woman called Rachel Gentile who proclaimed to be that person and Trayvon's girlfriend. And this movie and suit alleges that that was a lie, and it was a lie in service of denigrating Mr. Zimmerman as a murderer or wanton killer, rather than the self-defense survivor of an attack with which the defense claimed, and which, of course, he was ultimately acquitted for those charges.
So is this another iteration of hands up, don't shoot?
I mean, when you hear about the facts, Tim, as they allege, they are profoundly disturbing and include multiple levels of government, including the Justice Department, the Obama Justice Department, who paid for protests, you may recall, to bus people into Sanford,
I
to
do.
demonize George Zimmerman, a man who is a Hispanic, who has, before any of this went down, really did fight for civil rights for black people in his own town against the police.
It's true. It's been documented. And the problem is, Scott, it goes against the narrative. Just like hands up, don't shoot, just like Jussie Smollett, it goes against the narrative. So facts no longer matter. The narrative is everything with the left these days. We'll follow what happens with this. Now, it's almost like I thought you were inventing a term with this next story when you said justices are considering the copyright ability of state legislative codes. I understand what it means. I've just never seen it used before.
Just like it sounds, the ability to secure
Right.
copyright is what
Right.
we're talking
Right.
about. And what this is about is Georgia and other jurisdictions as well wish to control who gets to publish their laws and also profit from them. And so they often either sell the rights to publish them or publish them themselves and seek money from them. It's amazing, Tim, how even in 2019, with how open we think government could be with the internet and sunshine laws, there are still these barriers to people getting access to the laws. And this organization that promotes government access wants to basically publish the laws of Georgia. That's it, just so people know what the laws are. But they don't want them to without getting a check, okay? Even though the people are subject to being under that law. And so what Georgia has said is...
And it's just unbelievable.
It is unbelievable.
I mean, it really is.
What Georgia has said is because these publications themselves are not solely the laws, but they also include what are essentially like key citations to other laws, that those citations allow them to then secure a copyright and then charge and also defend it, so that the publicresource.org could not publish it. So that's what the case is about. I see you shaking your head, and it's unbelievable.
Okay, finally, Scott, 14 states are asking the Supreme Court to let President Trump and his administration resume federal executions. I had no idea that there was a movement afoot to resume federal executions.
There is. The Trump administration and the Barr Justice Department have tried to reanimate the execution machine, Tim, and they have been frustrated by courts who have ruled that they are acting outside the scope of the law because the law requires them to use execution methods of the state in which the crime occurred. And the federal law or the federal practice now does not do that. And so that's the challenge to this death penalty measure. And, Tim, I bring it to the fore because I always think It's a profound danger when the government wants it to make it easier to kill people.
Thank you, Scott.
Thanks, Tim.
This program, Liberty Nation Radio and LibertyNation.com's own podcast, The Uprising, hosted by Scott, and The Rabbit Hole, Politics and Prose, where past is prologue, hosted by our own dignified Brit, Mark Angelides. All of it available on demand at LibertyNation.com. So that is it for this week, but we'll be back at you next week. Same time, same station. In the meantime, this is Tim Donner saying stand up for liberty, and we'll see you next time on Liberty Nation Radio.